Hello, everyone. Welcome to tonight's Stark Financial Group Friends of the IRS mentor meeting. We're going to go over the new SPC book that I just finished and sent out to everybody. There's been some questions about it, and so I just wanted to kind of go over it, explain some things. So, uh, so here's the new book. I changed the artwork in it some, and basically what I did is I took the other books. So what I was doing before is we had like three books that went through all the information. So you would like go through each book and you did different parts of the process. And then I just took all the books and I just put it into one book and included all the templates and everything. So um title page, copyright stuff. So basically, when I had AI do this, they put it together like an actual book, right? So it describes the copyright and everything. Um, Disclaimer. So I'm not going to go through all that. You can read it. Private notice. Just basically that this is private company, private materials, and this is all designed to be in the private, right? Not in commerce. Debt dedication acknowledgement, just talking about, where the information came from. Table of contents. So the first thing is the foundations of a claim, right? The whole point of the secured party and creditor process is that you're establishing a claim, who is making the claim, and then who owes the claim, right? So a lot of people mistake this when they explain it because they call it, oh, I want to do the secured party creditor process. Okay, it's secured party and creditor. They're two separate capacities, right? So one of them is who's owed the money, and the other one is who's borrowing the money, right? So, like a bank is a creditor, and the secured party would be the person loaning the bank the money, right? So that's the foundation of a claim, and that goes through the foundation of a claim, equity and good faith, contract and private law, administrative process, special notice, and separation of title. Then part two is the lawful claim and title. This is the backbone of everything, right? This is the whole thing that we're trying to do is this lawful claim and title process where we are establishing our new claim, right, on the name, right? So then part three is perfection, preservation, and secured interests, right? Um, and then part four is the SBC framework, the actual like documents that we all do, right? And then administrative remedy, this is basically, it talks about after you've done the SPC and made your claim, how do you enforce it, right? So you got your administrative process, you got your fee schedules, and then you got your estoppel, default, and administrative remedy. So I'm going to show you all that stuff today. So then there's a forward, and then the introduction about what this is all about, right? And you guys can read that on your own. So part one is the foundations of a claim. The purpose of a claim is to establish the fundamental principles that support the lawful claim, public notice, and contractual relationships. This whole thing is based on contract, right? It's like um, the contract. I said this on Facebook the other day. It's like the contract, the right to contract is a God-given right above any law. It's like one of the first laws God ever established, right? Because he created a trust. So he had to establish the right to contract in order to create a contract, right? So the structure is equity, contract, administrative process, okay? Historical foundation of equity, contract as private law, administrative process, good faith and accountability, and preservation of lawful interests. Number two, public notice and constructive knowledge. Purpose of public notice, actual versus constructive notice. Record and public record, reliance and proximity, or priority, sorry. Notice as the evidentiary tool. And then separation of title and lawful interest, which is what we know about trust, right? That's the separation of title. So, chapter one, the foundation of a claim, in equity, the principle of fairness and good faith, right? So, this is what we're talking about. Hold on a second. So, this is what we're talking about when we're saying come with clean hands, right? Is to do everything in good faith, right? So when you are like doing anything in court, that's why we're noticing everybody. We're not trying to do shady, secret, under the table crap. We're trying to like put everything out there in the open, right? So notice the principle of notice, awareness, and accountability, right? So public notice, actual notice is putting something in the paper or sending, notice the number one way of notice is you actually send it to someone, right? You send them a letter, you send them an email. That's like actual notice. Constructive notice would be like posting posting a notice on the town board or something like that, right? And then contract, the principles of agreement and obligation. So essentially, we create a security agreement and an indemnity agreement, and then we create a UCC, and that creates the contract, right? So the foundations of the relationship is equity, notice, contract, and lawful claim. Okay. So equity and good faith, core principle is intent, good faith, fair dealings, which is justice, court, accountability, responsibility, reliance, that's trust. So that's can somebody rely on you always doing it the same, right? Clean hands, right? That's purity. It's like coming with clean hands, right? So, contract and private law, right? The core principle, agreement of all the parties, law of the contract, creation of obligations, private autonomy and freedom, right? That's your choice. That's being able to choose yes or no, right? Enforcement and remedy, and documentation and evidence, right? So, the elements of a valid contract: offer, acceptance, consideration, capacity, legal purpose equals a valid contract, right? So, um, do you guys know why legal purpose is in there? So, what does it mean? What does it mean to have legal purpose of a contract?
To have it in writing.
It's a legal purpose is you can't create a contract that is an illegal operation, right? Um, you can't you can't create a contract to buy and sell drugs, right? So this is equity, right? We're talking about equity. We're not talking about like at law. It doesn't matter what contract you make at law, as long as you follow the procedure in a courtroom, you're going to win or lose a court case. Okay, but in equity, everything is decided in these parameters, right? Um, so that's why legal purpose is in there, right? So that's what creates a valid contract in equity. So administrative process and evidentiary record, okay. Declaration of interest, notice and communication, documentation and record creation, filing and recording, evidentiary preservation, reliance and continuity, and remedy and enforcement, right? So um, these are the things that you need to be able to do with the contractual things that you're doing. The core principle is the administrative process is the mechanism through which claims are declared. notice is given, records are created, and the rights are preserved, right? So, uh, administrative process isn't always about, to me, it's more about creating a record. It's not so much about getting results, right? An administrative process isn't going to get you results right away. But have you ever been in a situation with a bank where they're taking a car back or they're like, you haven't made your payments on your house or something like that, right? They send letters, right? And do they, like, once in a while, they're going to call you on the phone and say, hey, you're going to make your payment. But when they start sending letters, they're doing an administrative process, right? So I went through a bankruptcy. And when I went through this bankruptcy, I did an administrative process on the bank, right? Because I'm the one that guaranteed the loan, right? So I did an admin process on them. And so when the bankruptcy was over and they were like supposed to like come get the property, they couldn't because I submitted a claim and my claim is higher than theirs because I'm the lender. I'm the one that gave them the money, right? So because I did the administrative process, they couldn't go through with whatever because my claim for the property was higher than the bank's. Does that make sense? So why was my claim higher than the bank's?
You just said it right because you're the lender,
Right, because I'm the lender, I'm the secured party.
and that as well. Yes.
Right. Creditor, right. So because I'm the secured party and the creditor, I was able to do that, right? So this is kind of like what I'm trying to like teach you guys through this whole thing in equity is like why these different things work. And like if you get something that doesn't work, what piece are you missing? Right? That's what I'm trying to like show you here is that like this is why we're doing what we do, right? So public notice and constructive knowledge, right? So when we put something on the record with Pima County, that's public notice. And it's one of the most effective public notices because it's on the probate record and it's indisputable. They never take it off, right? And the longer it sits on there, the better, right? So, core principle, this law does not require actual knowledge when proper notice is given. Public notice creates constructive knowledge for the world, right? So, do you know where they put traffic laws in your county? Anyone? Where do they post traffic laws in your county?
I mean, on their website, or are you talking about like speed limit signs?
No, Register of Deeds. So the county puts all of their statutory laws on the record at the Register of Deeds. So why do they do that?
They have to publicly post it, right?
Right, but it's your responsibility. It's your
To read it.
responsibility to know, right? So, like for example, if you go on somebody's property and trespass and you say, "Oh, I didn't know this was their property," then they're going to say, "Well, there's a public notice that it's their property." Well, I didn't know that. Well, that's not an excuse for ignorance. Okay, you can go to the Register of Deeds and look up any piece of property for free. So that's why they put laws there because it creates public notice and they don't have to tell you. They can just pull you over, right? So that's what that is. So a lot of the stuff I'm trying to teach you, I'm teaching you this like why why this works for us because it works for them, right? So Public notice and constructive knowledge, right? The foundation of awareness, priority, and reliance. Declaration of interest, public recording and filing, constructive knowledge, reliance and good faith, priority and perfection, and continuity and preservation. Okay. Um, Equity maxim behind this is the law helps the vigilant, not those who slumber on their rights. Okay. It is your right to go to the Register of Deeds and look up the laws. If you slumber on your right, equity doesn't protect you, right? So your ignorance of the law, i.e., you don't know, you haven't read the IRM and you don't know the IRS laws, but then you come in and say, "Oh, I didn't know that." Like that's not an excuse because the law helps the vigilant, not those that slumber on their rights, right? So if you know the laws when you go into court, you're going to end up on the better side of it than if you don't. All right, separation of title and lawful interest. Okay, legal title does not equal lawful and equitable interest, right? So we know this. We know this from creating trusts, right? Legal title is the trustee, and equitable title is the beneficiary, right? So just because the state has legal title to your car, it doesn't mean they have equitable interest, does it?
Nope.
So the person sitting in the car is the one with equitable interest, right?
Yes.
Right. So that's why that's important, right? Is to know that the legal owner is not necessarily the most important thing in there. Core principle, title, possession, and beneficial interest are not always held in the same party. The law recognizes and protects lawful interest even when legal title rests elsewhere. Okay. So creation, which is the relationship, the contract, trust, which is a car title is a trust, right? Separation, legal title may be held by another party. Recognition, the law recognizes lawful interests. Public notices, proper notice, right? So on this whole thing with the car title that we're talking about, what's what's notice? On a car title, what's the notice? So how do they give proper notice of the relationship on a car title?
They send it into the county where you're getting it registered.
They send you the title, right? Or they send it to the
A
bank.
certificate of title.
Hmm. That's notice.
Right.
So, and then enforcement, the lawful interest may be enforced through contract, equity, or law, right? So, some examples, lender holds security interest in property while the title remains with the borrower. Trustee holds legal title while beneficiaries hold equitable interest. A contractor assigns payment rights while the owner remains the title holder. The UCC filing perfects a security interest without transferring legal title, right? So now we're getting close to what we're supposed to be doing here. All right, so this is lawful claim of title, right? The purpose of the lawful claim of title is it's the foundational instruments that declares, preserves, and protects lawful interests through public notice, contractual authority, and administrative continuity. Okay, so it's the declaration of interest, declaration of authority, declaration of status, public notice, preservation of claims, contractual relationships, administrative continuity, evidentiary foundation, support for perfection, and enforcement. Okay. So this is how the claim functions. You have the declaration, the identification, the authority, the public notice, the administrative record, and contractual support, perfection, and enforcement. Okay. So the supporting components of the lawful claim framework, right? The lawful claim of title, These are the components of it. This is all what happens in one document that I'm sharing with you. Okay. The lawful claim of title is the cornerstone of lawful administration. It unifies declaration, notice, contract, record into a framework that upholds rights and preserves remedies. So let me get down here and show you this, right? So you guys recognize this. This is the lawful claim of title. This is all filled out by you, right? This is, in the matter of these all this all cap shit, right? The date, and then it goes through, and this is 44 pages of the different things. So it's the lawful claim of title, the will, execution of will, declaration of status, appointment of trustees, and standing orders for the same. So this is basically the document that you're putting on the record to establish with whoever goes on the record that you are not that other thing anymore. This is what separates everything, and this is you putting your claim on it, right? And you have a higher claim, right? We've talked about this before, right? Why do you have a higher claim in the title than anybody that would read it?
Because you're the owner of the equitable title.
Yeah, you're the body. Nobody else, well, nobody else is inhabiting your body, right? You are. So you are the only one, right? So everybody else can lay claim on all kinds of stuff, right? But at the end of the day, as soon as you make a claim, everybody else's is fuck all, right? So in the birth certificate, what's that? What That's a title, but what is that?
Isn't it a bond, right?
It's a trust relationship between you and the government saying that you will do certain things. You will pay certain things and contribute certain things to be a part of society. You accepted the share in the US corporation, so therefore you're obligated to perform, right? So they're giving you that. But once you hit the age of majority, you can put a claim in on it, right? You can put a claim and say, okay, thank you for what you've done for me for the last 25 years or 30 or 40 or 50 or whatever. But I'm going to put my claim in. So as soon as you put your claim in, everybody else's claim doesn't mean anything. So because you're doing that and because you're saying I'm claiming the legal right and I already have the equitable right, what happens when you are the legal and equitable both owners?
You win.
Yeah, you merge. It's called merger. It's the law, it's the doctrine of merger. Okay. So when the beneficiary and the trustee are vested in the same person, then merger occurs. You're not merging. Merger is a natural thing that occurs when that happens. Okay. But like I've said to you before you merge, you have to have something else to put it in, right? So you got to protect it. That's what this is. This is the notice that merger is taking place and all old claims and all old trustees and all old everything has got to they've got to seal this up. They've got to make everything right. They have to settle the account, right? So it's long, it's 44 pages, but that's in here, right? So this is the lawful claim of title. This is the basis of everything you do in the SBC, right? This is what everybody misses. Everybody else out there doing this, they don't do this. This is a trust relationship. This talks about the estate. This talks about your trustees. This talks about everything. Okay. So that's in here. To the end of it. So here is the quorum, right? So do you know it, do you know what a quorum is? Do you know why there's a quorum? You ever read Rob's rules or you ever go to a board meeting before? Any of you ever go to a board meeting before? You ever been on a committee?
No.
Okay. So when you do that, they operate meetings by what's called Rob's rules, right? And it's just the same. A meeting adjourned, somebody will, the chairman will I call the meeting to order. Can please go over last week's agenda, blah, blah, blah. That's Rob's rules. So part of Rob's rules is in order to have a vote, you have to have a quorum, right? And a quorum is a majority, right? So if there's 7 people in a meeting, how many people are a quorum?
Whoa.
That's right. So let's go back here. How many people's names are on here? There's 4, right?
Yep, 4.
That's a quorum. So you're saying that this is what my wishes are, and then you got 4 other people saying that they saw that this is what your wishes are. That's a quorum. That's a majority. It can't be contested, right? And then, so these are the unconventional witnesses, and this is your conventional witness. This is the professional witness, right? So that's what that is, right? Now it's 44 pages, read through it, whatever. If you read through the book, it's going to explain this whole thing to you, okay? Then after you do that, part 3 is perfected security interest, right? So foundation established, contractual structure, public notice and recording, evidentiary preservation, and secured interest perfected. So what's a secured interest? The secured party is a secured interest, right? So if you have the car and you owe the bank money, right? The bank has a secured interest, but they don't own the car, right? Well, what we're teaching you is through contract, you're creating secured interest through contract where you're the secured party, right? So, and we're doing that with this paperwork, right? So, perfected secured interest, um, authentication of the evidentiary record, right? So that's signatures, notarization, witnesses, seals and stamps, acknowledgments, right? So when you see me do a lot my stuff, all this stuff is there. All these 5 things are present when I sign a document or create a trust. Um, Public recording and constructive notice, that's putting on the record. A UCC filing is a public notice. Lien or judgment. Like, so if there's a judgment, a court case, that's public record, so on and so forth. Um, Administrative preservation of claims, right? Purpose is administrative preservation of claims, continuity protects evidence and supports the life and enforcement of a secured claim, right? So the declaration, financing statements, contracts, notices, correspondence, affidavits, and other supporting documents. Okay. This is basically what they do in a court case. A court case is a claim, right? So methods of administrative preservation, organized filing system, chronological timelines, secure storage, certified copies, mailing records, digital backups, and so on. So these are the ways that you do this. This is the way you preserve an administrative record, right? One of the ways is putting it on Pima County, like it never comes down, right? So here's into the SBC framework, okay? So chapter 13 is talking about the secured party and creditor structure. Chapter 14 is the UCC financing statements. Chapter 15 is the non-UCC filings and administrative notice. And chapter 16 is the security agreements and contractual control. So this is what is comprised of the 7 documents essentially that we put on the SPC. Okay. So chapter 13, secured party and creditor structure. You got the debtor, secured party, the collateral, and the creditor. Okay. Proceeds, income payments, rents and accounts, chattel paper, instruments, or other value derived from collateral. Okay. So the key principle is a secure relationship is sustained by clear parties, valid agreements, identifiable collateral, public notice, and continuous documentation. Okay, so it's not just like creating the record, but it's like keeping up with the administrative part of it. So like filing your claim form, a 1040, doing your 1099s, things like that. That's what they mean by keeping up. Okay. So the next one is the UCC financing statements. We all know what those are. And then non-UCC filings, we've all done those. And then security agreements and contractual control. So now I'm going to show you, this is all stuff that you've done, right? So here's the cover sheet, UCC, collateral, non-UCC. Here's another example, more collateral. And then security agreement and contract package. There's the security agreement. Hold harmless indemnity agreement, power of attorney, and then the administrative and remedy enforcement, right? So this is the administrative remedy. This is the foundation, then the notice, opportunity to cure, fee schedules, and contractual liability and default estoppel and enforcement. So estoppel is basically where once you do all this stuff, you've created an estoppel. It stops anybody from putting a claim in. So if you give people notice, an opportunity, right? And the longer that the notice is out there, the better it is, right? Notice, opportunity, right to cure, then there's a estoppel, right? There's a estoppel because you gave them notice and they didn't respond. So we always say like 21 days is enough, right? But the longer that you have it, I still have my notice. Remember the notice that I created months ago? That's still hanging up at the post office. Nobody's taking it down. And I'm leaving it there because the longer I keep it there, the more power it has, right? So administrative notice and opportunity to cure. So that's basically your conditional acceptance. Fee schedules, and then estoppel, default, and administrative remedy. Okay. So here it is. Administrative notice and private record package. So this is your common law copyright, and then declaration of allodial title. Okay. And then here's the fee schedule. I rewrote this, right? So anybody that does the new fee schedule, it's only like 4 pages. It's not 20 like the other one. So, and then the other thing that isn't in here, right, that we all have is the actual administrative process. I've given you guys like a half a dozen of them, right? There's all kinds of admin processes, and you're going to do different ones for different things. Like there's a special admin process for credit scores, right? And I've given you that one, and I've given them to you guys for all the different stuff. So you have all that stuff. So now, like a lot of you have already done this whole thing, but some of you are still like working through it or like are going to start doing it. But do you guys have any questions about this?
No, but that looks really cleaned up. That looks really nice the way you did that, man. That book looks much better.
Yeah, so that's what I'm trying to do is like go through all my books and like rewrite them. And the thing is that like organization is not my strong suit. Like I know the ideas, I know the concepts, I know how to like work through all this shit, but I don't when you like want to put it out on paper, so that it looks good and smooth so that people can comprehend it. Like I need to use some tools to do that. So that's why I use AI for that. Um, I Some people have this, like lately there's been a lot of like discussions on Facebook and whatever about AI and like should you use it, should you not use it? It's the devil, blah blah blah. Well, the thing is that there was a time when they were burning books. Right.
Yeah, yeah.
So, so like that's why I see it is that like if my if I have a controversy and that individual that I have a controversy with is using AI, then I'm going to, right? I'm not too proud to walk into a situation and not have the same tools as everybody else has, right? It's kind of like I wouldn't take a knife to a gunfight, right? It's just like you don't like go somewhere unarmed, right? It's the same thing with the law. Like, you can't come at the IRS without reading the IRM and knowing what the different laws are and how they represent it. So that's kind of like what that's about is that you have to establish your pecking order in that by using the same tools as they use. Now, lawyers have their own AI, right? And we've talked about this before, and it's really expensive. It's called Spellbound. It's one of them, and it's really expensive. So, um, you know, I don't know, like being pro se, it's just not feasible to spend 100 or 300 bucks a month for an AI program. But you can get your own going. A lot of people are using Claude, I guess, and I'm using ChatGPT. So that's what I've done. And I'm just kind of cleaning things up that way so things are just a little more cohesive and easier to read. And it's basically set up that, if you buy the book, you get the mentor program. If you buy the mentor program, you get the book, right? They're the same price, right? So it's uh it's set up so that everybody wins. So anyway, that's that's what that is. We did this. There's a couple people that couldn't make the meeting tonight, so I decided to do it on this instead of next week we'll do another one on the auto stuff um, and do more Q&A. And then we're going to roll into mortgages next. So um,
The last couple of videos I wasn't meetings I wasn't able to make. Did you post them somewhere in the classroom?
no, I don't record the Q&A
Oh, okay, okay, okay.
ones. I record like these ones and I record the actual lessons. But I'm trying to encourage people to attend the meetings because I want you guys to interact together and I want you to bring your questions in, right? So that everybody can interact with each other and learn, right? I don't, I'm not saying that we can't learn from watching recordings, and that's why some of the stuff is recorded, right? But I think that we learn better when we're interacting with each other. So, um, anyway, anybody else have any questions?
Can,
Yeah.
where else can you post the estoppel notification?
Well, if you have a court case, you can post it at the end of a court case, which is what I do. If I ever get a case dismissed, then I post the document at the end of a dismissal. The other thing is that you do it at Pima County. Like all the stuff that I did for you, I put on Pima County. So you can do that, or you can run it in the paper. But if you run the newspaper, most notices are going to cost you about 400 bucks to run the newspaper, and it's only $30 to send something to Pima County.
Thank you.
No problem. Anybody else got anything?
No questions here.
Okay, thank you.
I'm
All
good.
right. So I'm going to end it. This one's recorded, so it'll be posted, and we'll have another meeting Thursday, and then another one on Sunday again.
Super awesome.
Thank
Awesome.
you.
Thank you, Ken.
Yep. Thank you. Have a good night.
I appreciate you. Good night.
Yep.